welcome back to today's episode of the Future of Europe of the students of the Catholic University of Lille doing the International and European Law Master degree. Today's topic concerns intellectual property rights. In the last century, vectors of creation have not ceased to grow, especially platforms like YouTube, enabling authors of literary and artistic works to communicate these works to the public through new forms of exploitation. However, these new vectors generate an insecurity for authors and owners, as they enable an easier access of content that is more likely to be misused, leading to copyright infringement. Today, I have the great pleasure to welcome Julie Faure, who will talk about this subject. So, Julie, I would like to ask you a question. Should digital platforms like YouTube be liable for copyright infringing content posted by their users?
Well, that is an excellent question that has been addressed in the Peterson versus Google case, by which the Court of Justice of the European Union has based itself on two European directives, being the Copyright Directive and the Directive on Electronic Commerce. So the CJEU has enlightened this directive by interpreting several articles in order to be in line with today's common technology. So for a platform to be held liable, it firstly must make communication to the public. That means that there are two cumulative elements that enable to appreciate when a communication to the public occurs. First, there must be an act of communication, and secondly, it must be made available to the public. So making content available to the public is limited to the extent that the mere provision of physical facilities like YouTube or other broadcasting sharing platforms enabling or making a communication does not in itself amount to communication. So it's pretty subtle, and you can see that in this case YouTube does not make any communication to the public. So in this instance, the YouTube platform does not know or control the content that is being made available to the public. Plus, although YouTube is putting appropriate technological measures to avoid and prevent people to actually post illegal or protected content, it is not absolute. It does not have an absolute control over it. But at the same time, as YouTube ought to know that illegal content is being posted, we may question the economic model of YouTube that does actually incentivize people to post and to share this protected content. And nevertheless, the court has stated that the mere fact that YouTube knows that illegal content is being posted, it is not sufficient to consider that the platform actually intervenes deliberately in this process. And the court has also stated that even if this video sharing platform like YouTube or any other is aiming at making profit, it does not mean that it deliberately acts and intervenes in sharing this protected content.
So there must be a balance between the protection of copyright and freedom of expression, right?
Exactly. So on the one hand, there is a level of certainty and protection that must be assured for the copyright holders, but on the other hand, freedom of expression is at stake as well. So while some argue that when both rights collide, copyright is considered as stronger than freedom of expression because copyright is a right that is exclusive to one person, whereas freedom is equally distributed to everyone. And other authors also think that copyright protects the expression of the idea and not the idea itself. And it's pretty interesting here because you see that the expression of the idea is enabled by YouTube. So in this example, YouTube should actually be held liable.
So what has the court finally decided?
Well, the court has put freedom of speech at the forefront, so it did not follow the author's opinion, because it does, although freedom of speech is put at the forefront, it does not preclude copyright owners from their rights. YouTube has already implemented technological measures to prevent infringements on the platform, such as the content verification program. Further, YouTube has also developed a content recognition software enabling to recognize the people that illegally use protected content. And while the court has interpreted that YouTube does not make a communication to the public, copyright holders can still lodge an action against a person that has used their work illegally. And finally, right holders still have an interest on notifying operators like YouTube to notify them to if a third party has used their content.
Okay, so to conclude, should it be liable?
According to the Court of Justice of the European Union, it should not be held liable because YouTube is considered to have a neutral role, hence it cannot control or have knowledge on the content that is shared by third parties. But considering the divergent opinions that have already been given by the court along the years, one may ask to what extent such platforms are neutral regarding their high developed technologies that are actually being developed every day. So while the court has done an excellent job in interpreting the directives I mentioned at the beginning, we may reconsider the European Union shall maybe reconsider these directives that may not be very, that may be obsolete right now, considering the new technologies that will not cease being developed.
Thank you really much, Julie, for this intervention. It was a really interesting insight into the intellectual property world. It is the end of today's episode. We'll see you soon. Have a wonderful day.